This is The Bottom Line, a show designed to help Australian businesses succeed. On the show, you'll hear from leading Australian business owners as they share the lessons they've learned building their companies. You'll learn from their successes as well as some of the challenges they faced along the way. We also talk to experts from a range of fields who share specialised techniques you can use to improve your business. I'm your host, Sevan, and I'm a director at Alexander Spencer, and I'm really passionate about helping Australian businesses succeed. Have you ever wondered what it takes to sell your business or even buy a business? The legal process can be quite daunting, but don't be assured, we're joined by Craig Sanford, the director of Sierra Legal. He'll go through the legal process that a buyer needs to think about when he's selling his business, and we will touch on the seller's side and what is involved from a legal perspective from the seller's side. We touch on due diligence, warranties, the contract process, and how long these things take. So let's dive in and let's sell or buy your business. Craig, thank you so much for joining me on The Bottom Line.
Thanks for having me.
So before we get into Sierra Legal and your profession, take us back to your early days and what makes Craig tick.
I suppose I started my law degree, I did my law degree at Monash University, so I've always been, as you know, I live around the corner from you, Sevan. I've always been in that sort of Wheelers Hill area, so out that way, but I did my schooling and university out that way and got a law degree and then ploughed straight into the legal profession. I started my law career at one of the big law firms, K&L Gates, as it's now, Middleton's as it used to be called, and was there for 19 years, so straight out of university. And then back in 2010, living where we do out in Wheelers Hill, it takes, I think it was 12 and a half hours or so a week of travelling to and from the city, so I wasn't seeing a lot of the wife and kids and got that, and I suppose at the same time was getting that sort of entrepreneurial itch, or probably urge is the better word, entrepreneurial urge, I suppose, to do something a bit different, so decided to start my own business and start Sierra Legal, and that's where it began.
Tell us why law. So was it something you always wanted to do, or was it legal in your blood? How did wanting to do a law degree come about?
It was probably wanting to cover all bases. I mean, I had more of a maths and science background, and so I was just naturally going down that path and wasn't too sure that's where I wanted to go, but that's sort of what I always did. And so I did a science degree at university and sort of picking up on all the maths and subjects and that sort of thing that I did at school, but then thought, oh, why don't I do something else? So I did a law degree at the same time, and that was pretty normal to do a combined degree. So I did a combined science law degree to sort of cover all bases, if you like, and then sort of fell into the law, to be honest. You know, nothing on the science side sort of excited me too much, so sort of fell into the law and it went from there.
I wrote down that urge and that entrepreneurial urge you had. A lot of our listeners are business owners and some not, and they might want to have that urge. What was the urge? What was the spark? What was it that you wanted to do differently? Was it having control of your destiny? Was it doing legal differently? What made the urge really come to the surface?
Sort of just over a gradual time, I suppose, doing the same job for 19 years. I mean, the firm that I was at, K&L Gates, great firm. I think very highly of them, my time there, but doing the same thing, you know, getting the train into work, doing the same thing, trudging into work, the same thing every day. I remember every year as a partner, you get a review, and I remember the managing partner at the time telling me, you know, you're doing a great job, Craig, you're part of the furniture, you know, and he was probably thinking he was giving me a compliment, but at the time, that was actually a jolt to action. I thought, you know, if I don't do something different, I'm going to end up just doing the same thing, and they'll wheel me out of here as a consultant in, when I'm 70 years old. So I thought, even though it was a great place to work, I thought, let's spark it up a bit, I suppose, is probably what I was thinking, more looking forward and thinking, if I just keep doing the same thing, that's probably, if I don't do it now, the age I was in 2010, I'll never do it, you know?
Yeah. And Sierra Legal, you're wearing a T-shirt that says the business name on there. Most lawyers would have come here with a suit and jacket. So tell us what that little difference is, because we've talked about it. You have a unique law practice. You operate a little bit differently in the way that you hire the staff, how they work and where they work. Tell us a little bit about the edge that Sierra Legal brings to the legal profession.
Yeah, well, I suppose when you say operate differently, we're still lawyers and play everything by the book, if you like. But yeah, different, probably set up a little bit differently, a typical law firm. So when I started the business in 2010, it was predominantly a remote model. And so that could also almost be another podcast, how to run a remote business, but that was the model. So when COVID hit and everyone started using Zoom, we'd been using it for 8 years or so. So that's the model, because I'd been working so long in the city, and the thought that I'd spend a bit more time around the home and take a few overheads out of the business, etc., and try and be a bit more of a lean, mean machine, and get out of that ivory tower, I suppose, was in the city. Get out of that environment and more of a flexible sort of environment. And the staff we've got now, we've got the team. We're spread across Queensland and New South Wales, Victoria, South Australia, and we predominantly remote. We come together. I think that's still important, to come together occasionally and as a team, which we do, but predominantly we're a remote model, and a lot of the lawyers like me are out of the big firms wanting to get out of that ivory tower model and do something a bit different. And there's other aspects of the business too. We're probably one of the few law firms that we don't set personal budgets for our lawyers. So we think that if we do a good job, then because we've got that low overhead model, we can afford to do that, and we think that the rest will look after itself.
That's awesome. Well, you wouldn't have had any problems during COVID. You would have just seamlessly worked through it. And I would love to get you back for how to run a remote team. But let's talk about Sierra Legals. What are some of the services that you provide? And today we want to talk about M&A transactions and legal aspects to selling and buying businesses. But tell us what Sierra Legal sort of specialises in, the niche that you play in.
Yeah, we are very much a boutique commercial firm, so we really focus on M&A, or buying and selling businesses is what that is, and also just general corporate commercial law. So think of us as the friendly lawyers, Sevan. We steer away from the litigation and family law and conveyancing. We've got other lawyers we refer that sort of stuff on, so we have deliberately stayed very focused on that. And in that M&A space, we probably I have done the very big end of town deals and the smaller ones, but probably the sweet spot is those businesses that are selling for anywhere between sort of $3 and $100 million. That's sort of I suppose, the sweet spot for that for us.
So let's dive deep into it. So M&A refers to mergers and acquisitions, or buying and selling businesses, and part of that could be merging two businesses into one. What I'd like to get to understand from you is just run through sort of a process for a seller from a legal perspective, in terms of what they need to sort of think about before they go to market, just from a legal perspective on things that they need to just be aware of before they go out and plunge and hire a broker and go through this process.
That's a good point. I mean, a lot of business owners just want to plough straight into the process, and a lot of people just don't spend the time they should to kind of get their backyard in order. And the problem with not getting your backyard in order is that if you let a buyer into your business and they start doing due diligence and having a good look around, if they spot issues, that can all of a sudden bring down the confidence level of the buyer. It can probably is going to result in them trying to chisel down the price or possibly work sort of fairly onerous warranties and indemnities and the like into the sale agreement, or even worse still, walk away from the deal. So very important that for a seller to get their backyard in order before they go to market.
So what would be the process? So what are getting your backyard in order would look like from a legal perspective? What are some of the things that they need to consider to get right?
If we're asked to, it doesn't happen all the time, but if we're asked by a client to come in and do that sort of legal audit, it's essentially almost replicating what a buyer would do during the due diligence. So asking a whole lot of questions, extracting all the relevant documents and trawling through their business in a fine tooth comb to find any gaps, any legal issues. And to answer your question, the typical things that we come across sometimes. I mean, often the corporate register's a mess. That's something that you guys as accountants, Sevan, might see and might be able to help with, but it's a very simple thing to fix. But often the corporate register's a bit of a disaster, so the last thing you want to do is hand that over to a buyer before it's spick and span. PPSR registrations is another one that often sellers aren't aware of or don't fix up. I mean, a lot of sellers or target companies wouldn't be aware that they've got 10, sometimes hundreds of PPSR registrations or security interests registered against their business. And it might have just been a Xerox photocopier that they had 5 years ago, which they leased and was paid out years ago, but it's still a security interest there, and it needs to be removed, but no one's ever done that. So that can be something that can take time to remove those registrations and get it cleaned up. So that's another thing we spot. Intellectual property is another issue we sometimes uncover in these legal sort of audits. So particularly around, say, trademarks, people not using names and not registering them as trademarks or having let them lapse, etc. So that's something that we come across. Probably customer and supplier contracts would be another one. So some businesses are different. Some businesses don't necessarily always have contracts documented. But obviously, if you're selling a business, ideally you would have those sorts of things documented. Or if they are documented, often they're not signed properly or not dated. Or they might have ridiculously onerous provisions in there that, who knows, there might be an opportunity to look at those and perhaps renegotiate them before you put your business on the market. And the final probably example would be probably employees, not having employment arrangements properly documented with the staff, etc. That'd be so they're just a few examples of the sort of things that we might see if we go in early before the business goes onto the market.
That's really good, because what I'm hearing from that is not only do you get an opportunity to do like a reverse due diligence, sort of a seller's due diligence prior to sale. It allows you to sort of fix those things up. But at the same time, when a sale happens, you're really organised, so they're all ready to go. When there's a buyer's DD comes through and the information request comes around, you're ready to go. So that must really help buyers. How often do you see sellers that actually come to you and say, look, Craig, we're really keen on selling. It's more likely to happen than not likely. Let's go through this seller DD. Is it not done enough? Do you think that sellers need to do more of it?
Yeah, it's a minority of cases that probably where clients come to us and they're that organised that they want us to do that legal audit. There was a business we just recently sold, RCR, that you might have, if you're a home handy person, the Metal Mate and Carinya products you can buy in Bunnings, we acted for the sellers of that sort of distribution business. And the guy came to me some time ago and said, look, I'm thinking of selling. And he was very organised, and he said, let's have a look. Let's go through everything and see if there's any gaps there before we put it on the market. But I'd have to say it's probably a bit rare. A lot of people get that, we spoke about urges before, that urge to, it's a great idea to sell and they want to hit the market there and then. And I think most people probably skip that process of getting the backyard in order. But as you say, I think it can have some big advantages. But it does extend the process, because you've got to probably add another month or two onto the start of the process before you get things underway.
Craig, you went through really articulating, what you should do or can do prior to a sale. Now that the sale's happened, maybe they've agreed on the price, take us through sort of lawyers' involvement or the legal part of a sale process.
Yeah, sure. So as the lawyers, we would, even before that point, we spoke about the legal audit potentially if they want us to do that. But there's also some other tasks that we'd probably get involved in. In terms of the marketing of the business, there might be some legal input that's required from us in the information memorandum, those sorts of documents. The confidentiality agreement that needs to be signed with potential buyers before you let them loose on due diligence. Also, in the due diligence process itself, there might be legal questions that are asked by a buyer that the seller needs input from us on. So quite a bit of our involvement there as well. But you're right, once the deal's agreed in principle and it's all systems go, that's a large part of what we do. So documenting the agreements that are necessary for the deal to go through. So the main one obviously being the sale agreement or the sale and purchase agreement that documents the sale of the assets or the sale of the shares that are going through, but there might be other documents such as if there's only a partial sale of the shares, there might be a shareholders agreement that needs to be done. There might be employment agreements for key staff. There might be a transitional services agreement to allow for a period after completion for the seller to gradually work services, etc., or the systems across to the buyer. So we typically get involved in all of that, and so we'd help the client with the drafting and the negotiation and eventually the signing of those documents. And then once that's done, often there'll be conditions precedent to the sale going through. So things like getting consents of landlords or customers and suppliers where the contracts require that consent before the deal goes through, or maybe as a seller you're trying to avoid this, but a finance condition, subject to the deal doesn't go through until the buyer gets their finance in place, or there could be ACCC or FIRB approval, for example. So we might do a fair bit of work in terms of getting those conditions satisfied and over the line, and then our final job, I guess, is the completion process when the seller gets their money, and usually it's the lawyers that kind of drive that process as well and make sure that goes through.
So how long does it normally take? So what's the sort of the timeline, say from the time that the buyer and the seller sort of generally agree to terms and you're ready to go from a legal perspective and you're now getting close to executing the deal? From start to finish, how long does the legal paperwork or that legal last stage take?
It depends, of course, like everything, but the stage of getting an in-principle agreement with a buyer, that itself can take a while because obviously there's going to be a marketing phase in going out with the information memorandum, getting offers in for potential buyers. I mean, all that process can even take it. That itself can take months, So once you have a buyer and you've maybe signed an offer or a term sheet or something, from there to signing documents to completing the deal, I've done as quickly as as a month, but you'd probably say maybe 3-4 months, something like that. For a transaction of that sort of 5 to 100 mil range, that'd be sort of a typical time period, I think. And it really depends. I mean, I've done a lot quicker. I did one deal, it was a few years ago now, where it was a sale of a steel fabrication business in Perth, and whatever, I think for confidentiality reasons, they wanted to use East Coast advisors. So we flew over and were given a week to do the deal. It was a $100 million transaction. And I was acting for the sellers, and we were told we had to get it done in a week. So the way we worked that one is I said to all the advisors sitting around a table, I said, the only way we're going to do this is, as the lawyer preparing the sale agreement, let's do it this way. The first draft, it's going to be in the middle, not super seller friendly, not super buyer friendly. But the deal is, unfortunately, I knew the lawyer on the other side. I'd previously worked with him as a fellow partner in where I worked.
So that would have helped.
And I got it was a handshake deal that he wouldn't then use that opportunity to abuse that to make it a more of a buyer friendly documents. And so issued the first draft right down the middle. We cut the lawyering out of the deal, and it was a couple of back and forths, if you like, and we had it signed in a week. So it can be done quicker, but on the other side of the equation, you could have a very heavily negotiated process that could take a couple of months.
Sometimes it's said that lawyers can ruin deals or drag out deals to a point where it becomes really, the time factor becomes really difficult. Buyers and sellers are trying to get a deal done, and then the lawyers get involved and it goes backwards and forwards. You've been able to articulate a process there where it was done quickly. What advice do you have to buyers and feedback to lawyers in trying to make it so that it is a seamless process? Because I feel like sometimes when the two lawyers get involved, it does become about the two law firms around arguing about things that sometimes don't even matter. What advice do you have to buyers to mitigate a long, drawn-out process, but at the same time not give up some of your rights and things that you want to have? So how can we get it to a shorter period? What communication can buyers have to their lawyers to make sure it doesn't drag out?
Yeah, and I should just begin the response to that by saying that the same probably applies to accountants as well.
I do agree with that.
In terms of the key for a seller or a buyer is to pick advisors that aren't going to get in the way of the deal, because unfortunately the way a lot of lawyers and accountants charge is on the hour. So if the longer it takes and the more convoluted it gets, then sometimes the higher the fee. So it's a bit of a short-term gain there, but that's the last thing you need. So my suggestion for a buyer or seller when they're engaging a lawyer, accountant or a corporate advisor is to ask them about their previous deals and then actually go and speak to the client or clients that they've acted for, pick 3 of them, go and have a chat to them and say, how did they run the deal? Because I think certain advisors are just wired that way to be a bit more confrontational, if you like, and others are wired in a way where, there is a balance there. You just don't want to roll over on everything. You need to protect your client's position, but at the same token, you don't want to get in the way of the deal, and you want to get through to a successful deal for everyone. So I think that's important to do your research. Just like employing an employee, you wouldn't do that without getting a reference.
Yeah,
so,
I agree with that.
That's what I'd suggest.
I totally agree on the accounting side. We've got an M&A division here, and we're starting to see the accountants. We don't really talk to accountants much, and or even see some of their work. But geez, I can tell you what, there's some accountants that get really in the way of deals. We've seen that happen before. But one of the things I wanted to sort of touch on is I was involved in a transaction many years ago now, and we were on the seller's side, and the seller's lawyer was it was a sole practitioner, but he was a really high-end lawyer. It was an M&A lawyer. And he did something which made the deal really quick, which is very similar to what you did in Perth. And I think it was Cadence or another big firm on the other side. And he actually said that we're not going to do this via email. We're going to get to 90% of the document agreed on just in a round table. So I think what happened was, I can't remember who drafted the first agreement, but someone drafted an agreement, and I was sat in a room for like 8 hours all day and negotiating and talking through the document live. And it was done within a week or two. The legal component of the deal was pretty much sealed. And he drove that process. He sort of said, no, we're not going to try to do this sort of email. This was pre-COVID, so there was no Teams, and organise a meeting. And then it really narrowed that. So I think there's a merit to sort of just, instead of doing it sort of the old-fashioned way where you're marking up documents left, right and centre, it's just get in a room and look at the key principles of what's important to both parties and focus on that.
Yeah, no, I
So
think
yeah,
that's a good idea. And I think that just to add to that, I think a good idea is to get the decision makers, like the clients, in the
yeah,
room as well, because if a lawyer or an accountant is arguing a ridiculous position, it's very easy to do that and hide behind emails. But if you're in a room and you're looking and you're sitting across a table like this, it's very hard to kind of get away with that. If you've got 10 people in the room, all saying, "Oh, that's a ridiculous point,"
yeah.
and so it's a natural pressure just to get to a point, and you tell everybody we're not leaving until this agreement's finally agreed. So no, it's a
So let's dive into a little bit of the technical component of selling. So you mentioned in the conversation earlier, if it's a sale of shares or sale of assets, can you tell our listeners sort of what are the differences in how you sell a business? There's obviously a share sale and there's an asset sale. Can you just define so we get a bit of education around what those two things mean?
Yeah, sure. So asset deal, as the name suggests, is that you're selling the assets of the company or the entity that's running the business. And so the seller, in other words, is that company or entity that is conducting the business. And so as a result of that, part of an asset sale, it will involve the transfer of contracts, leases, employees across to the buyer. On the other side, a share deal is where the seller is actually the shareholder or the shareholders in the entity that's conducting the business. And so you're selling the shares in that entity across to the buyer. And because you're doing that, there's no need to transfer contracts and employees, etc., because it's just going across automatically with the company. And in terms of what's best, in relation to that, it's sort of that deal size, 5 to 100 mil. Typically, they do end up being share deals, and this is more in your area, Sevan. I mean, as you know, that you're probably better to talk to this, but the tax advantages for doing a share deal, particularly with CGT discounts and the like, probably make a share deal a better way to go. There's also the advantage is, as I said, you don't have to worry about assigning individual contracts. It's probably a bit more straightforward in that regard because everything just comes across with the company, including liabilities. The buyer, however, often might have a preference for an asset deal because they can effectively cherry pick which assets and employees they want, and they can leave unwanted liabilities or unknown liabilities behind. But the key with all that, I think, is to, as I said, it's typically for a transaction the sort of size we're talking about, you do a share deal, but asset deals do happen, particularly the lower end of the market and other areas as well, say for a receivership sale or something where you're not going to be selling the company, you'll be selling the assets. But the key, I think, is to work that out early. We did the example of not to do, I suppose, was we acted for the founders of Hampus with Byte as a corporate hampers company that sold to Pentel, a listed company, and on the ASX. And the founders came to us and we acted for them in the sale. And they initially had agreed before we got involved that it would be an asset deal. It's something that the purchaser as a listed company wanted to do, and not take all the hidden liabilities and that sort of thing. But I said to one of the founders, Rory, I said, mate, you need to have a chat to your accountant to see whether this is a good way to do it, because I suspect you're going to end up a lot worse off, by doing an asset deal. And unfortunately, the deal was a great success. It went through and all that sort of thing. But unfortunately, there was that little blip at the start where he kind of left it a few weeks before he spoke to his accountant, which he did eventually, and eventually he came back and said, "Hey, Craig, you're right. It should be we should have done a share deal." But by that point, the agreements had been largely drafted. The buyer had done their due diligence, so we had to flip it around because there was quite a big difference from, we're talking a lot of dough in terms of the differential between an asset deal and a share deal and what it would mean from a tax perspective. So we had to flip the deal around, which meant redoing the sale agreement. The buyer had to come in and do additional due diligence. So it added some delays and costs to the process, but fortunately it still got away.
Yeah, look, it's not about the topic today, but definitely you got to get some accounting advice prior to putting your business on the market, because eventually you got to sort of dictate what you're selling. Sometimes when you go to market, you generally go to market telling them what it is you're selling. You're selling shares or you're selling assets. And a lot of buyers don't get the tax advice first. And I definitely encourage sellers to go out and figure out, if I sell for X, what is going to be what I bank after tax? And they find that out later in your example and they go, oh no, should have done it this way. In that case, you were very lucky that the ASX company were happy to go back and do it as a share sale, but they could have easily have said, you know what, it's an asset sale or I'm gone. And you end up having a situation where you're very at the pointy end of the deal and things don't go well. So, but you mentioned there's obviously a little bit more additional DD that needs to be done in a share sale. The buyer's obviously going to continue to own the corporate entity that, has a history. What are the things in that DD from a legal perspective that are looked at generally that a lawyer needs to just tick those boxes that their company has a good, healthy history?
Yeah, well, it's probably similar. It's the reverse of the legal audit thing, isn't it, really? So,
Yeah.
but really, typically a buyer's lawyer would go through the whole thing, so corporate register, the contracts, the regulatory issues, the leases, property holdings, all the legal aspects that go with every aspect. But some buyers, we do some work for private equity firms, and that can be a pretty expensive, time-consuming process. And so, the more astute buyers might make a bit of an assessment as to what are the key risk areas. So, typically, we might be wheeled in to just look at the top 10 key contracts or some regulatory issues and maybe employment issues or something, and not just the whole thing. The danger for a buyer is you just let your lawyers and accountants let them loose on due diligence, and before you know it, you've got a massive legal
Invoice.
bill and not much to show for it. So the more astute buyers are probably a bit more laser focused on what you look at from a DD perspective.
And can the seller put some warranties in place? Because obviously you can't, like you said, do a DD on every single thing that can happen. Let's say I buy a company, I buy the shares. A year later, we get a tax audit from 2 years, or we get an ex-employee making a work cover or a claim of stuff that happened prior to me buying this business. How do you put legal parameters inside a contract that allows me to, not get intertwined to things that I wasn't in control of?
Yeah, well, you're getting into the warranties and indemnities now, but putting aside the purchase price, probably the most heavily negotiated aspect of an M&A deal would be around warranties and indemnities, which you're touching on. And really what warranties are their promises or statements made by the seller about their business, that warranty that they might make a warranty that they own all of the assets or the shares in the target company, or that they're not in breach of contracts, they're complying with all laws, et cetera, et cetera. So you get pages of warranties usually that get negotiated. And sitting around that is often a regime, limitations that sit around that, and things like, as an example, you wouldn't want a buyer making a warranty claim where they sue the seller for breach of warranty and that the amount they're suing them for is actually more than the purchase price that the seller claims. So you often have caps around what the buyer can claim and time limits, et cetera. And as I said, that's pretty heavily negotiated. I think priority should be due diligence though, and really I see warranties, the warranty regime as a bit of a backstop. If things slip between the cracks and things come up out of the woodwork down the track, you've at least got an avenue for the buyer to have a crack at the seller. But sometimes that's not ideal, particularly if the seller's still in the business. They might be the CEO of the business that's been purchased by the buyer, for example, and it's not terribly good for the relationship if the buyer's suing the seller at the same time. But yeah, it is a heavily negotiated thing. I'd have to admit, probably lawyers do tend to get a bit carried away with that warranty indemnity regime sometimes. Sometimes lawyers just seem to focus. I know you've been involved in deals and they do probably tend to get a bit carried away. We had a deal not that long ago where we were acting for the seller of about a $30 million business, and it was a big firm on the other side, and we spent days negotiating these warranties and indemnities, but they didn't touch other parts of the agreement, like our first draft of the sale agreement only put a 2-year restraint on the founders and didn't touch that. I mean, normally you'd have like a 5-year restraint, for example, but they didn't even ask to get. I mean, they were just so fixated on the warranties and indemnities because that's what often happens. But it still is important, but I still think due diligence is certainly a equally, if not a more important, focus for the buyer.
You touched on restraint. So you want to protect yourself. You bought this awesome business. The founder's probably a key driver of sort of the idea around the business and knows all the secret sources. You want to protect that he doesn't go across the road and start again. And I know with the ACCC and how consumer works that, you can't restrict people to earn an income. What legally boundaries can you put on a founder that they don't go out and start again and become a competitor very soon after that? You mentioned standard is 2 to 5 years or whatever it is. Can that be fought in court and say, well, no, 5 years is too long? So how does a buyer protect themselves from the founder not starting again, or even employees not starting again? So talk us through sort of what are the risks there and how do we mitigate them?
Yeah, certainly restraints, you've got to be careful of. Courts as a general rule, don't like restraints.
Yeah.
So in an employment scenario, it's very hard for that reason to put restraints on people for more than, say, a few months or whatever, for that very reason. But for a sale of a business, sale of a company, where the seller is receiving a good lick of cash, courts are far more inclined to allow restraints of 3, 4, 5 years. They've got good consideration for the deal. It's a bit rough if they take their money and then just start up a competing business. So it's a different sort of scenario. So a restraint, you still need to be careful and draft it carefully and not be ridiculous about it, but a restraint that goes a bit longer than your typical employment restraint is generally acceptable in a M&A transaction to protect the goodwill that's been sold and paid for.
Awesome. Can you tell us an example of a transaction that went really well? And love for you to take us through that journey so listeners can hear what they should try to achieve if they go to sell their business.
Probably a transaction that comes to mind was a few years ago. We were acting for the founder of a consumer finance business, and it sold for $15 million or something. And the business at the time probably wasn't going particularly well, but the seller that was a lot bigger and they just wanted, for strategic reasons or whatever, just had to do the deal. So they came along and didn't do a lot of due diligence. They sort of knew they were in the industry, so they knew the business very well. So, that due diligence was very quick. Lawyers acting for the seller, we did the first draft of the agreement and very little pushback on the provisions. They were very commercial. There was no earn-out for vendor or the seller. So the transaction just went through so smoothly, so quickly. And so much so that completion happened and the founder, just in his 20s at the time, was able to take a year off and travel around Europe for a year with his wife. So everyone was happy.
That's a good one. What about in reverse, something that was really tough and things that probably didn't go so well in a deal? Can you run us through a transaction you were involved in where you're like, if I had my time again, I'd do this completely. Maybe not you do it completely differently, but, this could have been done differently.
Yeah, probably the toughest deal I've done is probably the acquisition of Clark Rubber. So you've probably heard of the Clark Rubber business. So we acted for the buyers of that business. And unfortunately, after the process commenced, we found ourselves right bang smack in the middle of COVID. So timing was probably more the issue with that one, but it was quite a big business, successful business, and quite complicated. There was a lot of other agreements that were involved in the transaction. Banks were involved, so banks at the best of times can be difficult to deal with, but let alone in COVID and before. Remember, the laws were changed around the electronic signing of documents, and so everything had to be signed in wet ink and in person and all that sort of thing. And we had overlaying that were all of the COVID restrictions about who you could see and couldn't see. And so that was just a really hard slog. And I suppose the good thing with COVID is weren't allowed out of the house, so you couldn't do much else. Everyone was focused on the deal because there wasn't much else to do. And the personality, everyone sort of wanted to get the deal done. And a lot of people knew each other. I think I went through uni with the partner in Maddox who was acting for the seller, and I knew the Canterbury partners. I went through school with the guy at Canterbury Partners who was acting for the seller as well. So sort of there was a bit of goodwill there and everyone wanted to do the deal and eventually got done. But that was a pretty hard slog, I'd say, but probably more the timing around COVID, etc.
And my last question is a twofold. What's one piece of advice you'd give to a buyer? And what's one piece of advice you'd give to a seller that's looking at either selling their business or buying a business?
Okay, in terms of a seller, I'd have to say preparation, getting your backyard in order and getting your advisors in early, because it's all about that preparation. You don't want to give the buyers any surprises, any excuses to chisel on the price. And I have to say on the reverse, you'd say the same. It's all about getting the advisors in early and doing your due diligence thoroughly and in a laser-focused manner that you get to the bottom of the key issues early and deal with them accordingly. So it's mainly about preparation and not doing these things in the seat of your pants.
And is there anything unique that a seller can do to acquire a business in an efficient manner from their perspective?
The other danger, I suppose, I see with sellers is they take their eye off the ball. So as soon as they get this magical prospect of a huge deal from a buyer, particularly entrepreneurs, and they mightn't have done this before, and they get all excited, and this is the new shiny toy, and they take their eye totally off the ball in terms of the day-to-day operation of the business, and I just see it. I see it a lot. The danger with that is that if the business performance drops off, and you've got a sale process that's taking a few months, then the danger is that the buyer's going to start using that as an excuse to chisel the price, or again get terms and conditions in there that aren't favourable, or worse still, pull out of the deal. And secondly, if they do pull out of the deal, the seller's left with this shell of its former business, that they had. So I find, in my experience, a danger for sellers not to get consumed by the process. Leave the process to the experts and keep focused on the day-to-day operation of the business.
Yeah, I could definitely vouch for that. I think that's the most important thing. I think you really need to be prepared as a seller that there's going to take a lot of effort and energy to sell your business. But I can vouch for that because one of the sales that we were involved in, which actually took about 6 to 9 months, we had to do monthly reporting to the buyer every single month on how the business was performing. Now, fortunately, that particular business did really well along that journey. And I think we ended up negotiating a higher earnout. There was an earnout component in that deal. And we're able to, because of the performance, actually nearly at the tail end get a better earnout negotiation. However, it could have gone the other way. Their finger was on the pulse of how the business was operating. And I think that's great advice, Craig, because a lot of sellers, they see it as their last sale and it's their biggest transaction. So they get so invested in it that they can potentially, drop the ball in the day-to-day and the strategic part of their business. And everyone's looking at your business with a fine-tooth comb in that moment. So, a lot of things have to go right. And yeah, so great advice there, Craig. But look, Craig, we can chat about this forever. We could have touched on, deep into what PPSR is and what earnout is. I might have to get you on again and we can continue our conversation around on M&A transactions and how we can make them successful. But I just want to say thank you so much for joining me on The Bottom Line. I thoroughly enjoyed our conversation.
Thanks, Sevan, and really enjoyed being on the show.
Awesome. This is The Bottom Line, a show designed to help Australian businesses succeed. This podcast was produced by accountancy firm Alexander Spencer. At Alexander Spencer, we've been helping business owners realise their goals since 1952, and we play a pivotal role in developing, implementing, and supervising the business goals and strategies of our clients. To find out how we can help your business succeed, head to our website, alexanderspencer.com.au. To make sure you don't miss an episode of The Bottom Line, be sure to subscribe to or follow the show in your podcast app. And while you're there, leave us a 5-star review. It really helps others find the show. I'm Sevan Tuna, and we'll be back next episode with more tips to help you transform your business. And that's The Bottom Line.